Anne-Marie, thank you very much indeed, and good evening. On behalf of the trustees of the Ecclesiastical Law Society, can I welcome you warmly to this evening's London lecture. It's a great privilege this evening to welcome the Reverend Dr Helen Hall, who will deliver our lecture this evening. Helen is an associate professor at Nottingham Trent University and an Anglican priest, currently based in the Diocese of Sutherland, Nottingham. She read law at Peterhouse, Cambridge, and is a qualified solicitor. Her academic interests span law and religion, human rights, family law, and tort. It's also great for me that Helen and I both teach on the LLM in canon law at Cardiff University, so it's good to welcome a friend here this evening. Just a reminder that the chat function is restricted to questions you wish to raise at the end of the lecture. So at the end of the lecture, I will read out the relevant question, and then please use the raise hand function so that Anne-Marie can find you to unmute you. So chat function, just for the questions you wish to raise at the end, and then at the end, I will read out your question and ask you to use the raise hand so that you can be unmuted and you can ask the question. So without further ado, I'm going to hand over to Helen, who is going to deliver this evening's lecture entitled Exorcism and the Law. Thank you, Helen.
Thank you very much for your lovely introduction, Stephen. Now, the obligatory faffing to share the screen, which I hope will work. Fantastic. Well, firstly, may I start by saying how honoured and grateful I am to have received this invitation. It certainly wasn't expected, but I do very much appreciate an opportunity to speak to the Ecclesiastical Law Society. And even though I am suitably honoured, I also feel that I'm among friends. So it's a really lovely opportunity for me. I'm going, as you know, to be talking about exorcism and the law. It's a topic that I've written about a fair bit, both on my own and also with my wonderful and frequent co-author, Dr. Javier Garcia Oliva. Clearly, it's a very wide-ranging topic, and it's not going to be possible for me to say absolutely everything that might be relevant to it in the scope of this lecture. I'm not going to really speak very much about Anglican canon law on this topic because the position is fairly straightforward and very well known. Similarly, I'm not going to say a lot about issues around vulnerability and safeguarding because they're matters which generalise. But obviously, in the chat afterwards, you're very welcome to ask and to raise anything about that that you might like to. However, despite the disclaimers of everything I'm not going to talk about, perhaps more relevant, what am I going to say? I'm going to briefly look at an appropriate definition for what I've labelled exorcism for present purposes, and the way in which the law of the state interacts with this group of religious and cultural practices. We are going to see how disparate the landscape is, and as a result of that, I will pause and ask the question, well, is it actually helpful and appropriate to bundle all of these things together? And then I intend to move on to the main body of my lecture and to look at three distinct substantial topics. Firstly, criminal law, adults and consent. Secondly, exorcism and minors. And thirdly, issues of civil liability, before I wrap up with some of my conclusions. So to begin with the important preliminary point, when we use this word exorcism, which can be quite a loaded word, it's one which conjures up various associations for various people. Many religious denominations choose not to use this word in their everyday parlance. What is it that I'm intending to convey? A definition I've quite often adopted and propose to adopt tonight is as follows. Any rite or practice intended to free a person, place, or object from an external malign spiritual influence. Now, this covers two things. It covers one, a really wide range of different kinds of practices and outward manifestations that might come within this basket. And two, it covers a wide range of different underlying beliefs, because as we know, sometimes two people can carry out very similar actions, So an observer might believe that the same thing more or less was going on, but the internal understanding of the parties could be very different, and this can have important practical applications. So thinking about the first of these to begin with, outward manifestations and actions. And I'd want to stress to begin with that these are immensely varied, and this is just a few of the different kinds of religious and cultural practices we might be talking about. Some traditions involve the speaking of words, possibly accompanied by the laying on of hands, sometimes yes, sometimes no. Burning incense or other substances, for example, sage leaves are quite popular in some circles. Sometimes subjecting a human body to pain, the idea there often being that it's being occupied or at least used by some malevolent external force or being. And if you make the vessel an unpleasant place to be, then it's encouraging it to get on its way. And you might make it unpleasant in a variety of ways, through cold, through heat, hunger, thirst, even beating. Sometimes drinking water or another liquid. This might be done voluntarily. Sometimes it's even forced upon the person. If any of you have seen quite a well-known documentary from not so long ago, the 2000s, about a young woman called Janet Moses in New Zealand. She was forced to drink water, and this was ultimately the factor that led to her death through dry drowning in an exorcism ritual. Sometimes the person is encouraged to hold or to wear some form of sacred object. Sometimes they might be asked to bathe in water or another substance, or perhaps have it sprinkled on them. Sometimes it might be a case of burying or strategically placing or scattering some substance or object. This is something that I think a lot of people in England and the north of Europe are familiar with from some of the things we know about the 17th century and beliefs about witchcrafts and spirits and certain objects being hidden in the walls of houses and things like this. But it is something which is a practice for some contemporary groups as well. Obviously, this is not an exhaustive list. Some of these things can be used in conjunction. Some of them are intrinsically benign. Some of them are intrinsically dangerous. Some of them may be benign or dangerous depending on how exactly it is that you're doing it. Second issue, underlying beliefs. Now, these vary immensely as well. Beliefs vary as to the nature of the external force. So some religious traditions believe in spiritual beings which might attack human beings, so demons or jinn, for instance. Sometimes beings are believed to be members of the dead with malevolent intentions, something like a dybbuk in some Jewish mystical traditions. Also, beliefs vary as to how the person who is perceived to be in need of exorcism is regarded. Some faiths and cultural groups might consider being in need of exorcism something which just happens, like, you know, catching the flu. Sometimes it's regarded as something which only happens if somebody has behaved irresponsibly or transgressed some kind of boundary. Equally, the person may or may not be regarded with stigma. They may or not be regarded as dangerous, either physically or spiritually, to other people around them. In some contexts, it might even confer status. It might even be regarded as almost a positive thing, either because the person is seen as being a particularly good and holy and desirable, and that's why they've been targeted by whatever it is that has attacked them. Or it might be something that garners attention, and attention itself is seen as being positive. Now, these factors are obviously immensely interesting from an anthropological point of view, but they're something that are also important to lawyers. Because if you consider for a moment the implications of those kind of factors, it's clear that they make a difference when we're thinking about consent and how freely somebody may or may not have signed up to a practice, or whether they've been coerced into doing something. You may, as an adult, ostensibly freely agree to take part in an exorcism, but if the alternative is going to be excluded from your social, maybe even your family group, well, how free and genuine is that consent? We've seen a very wide variety of different ideas and practices put together. I would acknowledge that I've spent a little bit more time on the ones that are dramatic and potentially dangerous. That's not to imply that all exorcism practices are in that category. They are most certainly not, but obviously it's those that are going to attract the attention of the law of the state. Is it appropriate to bring all of this together? Are we in danger of comparing apples and oranges, importing one set of assumptions from contexts with which we're familiar and forcing them into another one? I think that's an important question to ask. And I would very much want to say that that is a real risk, but it's a risk that we can be alive to and to guard against. And I would obviously consider that it is appropriate and helpful to analyse these practices together in the intellectual basket in which I've placed them. That's because of the common threads which I've identified in the definition, and the parallels which will therefore inevitably be drawn both by judges looking at these matters and also members of the general public hearing or reading about them and considering their own interactions with the legal system. We do have a duty to treat like situations as being like if we have a serious commitment to equality. And there is always a risk of regarding things that are familiar to us and our traditions as being reasonable and acceptable, and considering matters which are strange to our particular tradition and experience as being somehow intrinsically more threatening, or to dramatize things that other people do and imagine that they are somehow different and more extreme as a matter of necessity rather than investigating. So taking all of these considerations together, I would argue that considering exorcism in this rather broad, general way is both useful and necessary. So having completed the preliminaries, if you like, I will move on to the first of my substantive topics: criminal law, adults, and consent. Now, this is an area that has perennially come up in the context of exorcisms coming before courts in the real world, rather than in some kind of hypothetical sense. Any of you who have studied law at any level since the 1990s are likely to be familiar of the case of Crown against Brown. If you haven't, just to briefly remind you, it's a case about a group of sadomasochists and the legality of their practices that made it as far as the House of Lords, and indeed in a slightly different incarnation, the case got as far as Strasbourg. As far as the law of England and Wales goes, it set out the outer limits of consent when it comes to physical violence. What can a person give operative legal consent to? And the answer is essentially only common assault. So if anything is more than transient or trifling, so it makes the threshold for actual bodily harm, or of course exceeds the threshold for actual bodily harm, then it is going to be a criminal offence unless it comes within one of the exempt categories of activity the law recognises. For instance, we have our boxing gloves there. That's a well-known and well-accepted exception. This means that hitting or otherwise causing actual bodily harm in the course of an exorcism will also be unlawful unless we can get it within one of the categories that the law recognises. Now, the case of the Crown against Brown referred to the exempt category of religious mortification. Question: can religious mortification cover exorcism? My answer is, in short, no. This is a controversial point in some ways, but I think I have a fairly robust argument in pushing it back and saying that it doesn't. Firstly, I don't think including exorcism as we've defined it is a very natural reading of the words religious mortification. I think we tend to think of things like the medieval flagellantes that you've got on your screen. We tend to think of somebody disciplining their own body for their own spiritual good, not someone doing this to somebody else, and not someone trying to necessarily rid an external entity. Secondly, the comments about religious mortification were made obiter. This was a judge who was thinking about sexual consent between adults and was reeling off other instances where the law might allow or not physical assault. There was no serious attempt to turn the minds of the judges involved to the question of something like exorcism. And given the delicacy and seriousness of what's at stake, I think it would be unreasonable to try to shoehorn it into being lawful on the basis of an almost throwaway obiter statement. Secondly, when consent has been, when exorcism has been considered by the criminal courts in this jurisdiction, consent has not been regarded as a possible defence for those who have been prosecuted. And a particularly sad case is the Patel case. Again, not long after Brown, it comes from the mid-1990s. And it illustrates, although the facts are distressing, they illustrate some of the dangers in this area. A young woman was suffering from a variety of mental health symptoms, and her family, who were very loving and devoted to her, were convinced by a female spiritual advisor at their mosque that it would be appropriate to carry out an exorcism on her, and that this required beating. The family, particularly her younger brother, were extremely reluctant to take part and to hurt her. An immense amount of pressure was placed on them. And none of them actually, when it came to the criminal trial, denied what had happened. The only person who actually even tried for a defense was the spiritual advisor who'd instigated the whole thing. But her younger brother, who was effectively coerced into doing the beating, was extremely distressed, but was told, look, if you don't do this, you're abandoning your sister to an evil spirit. If you love your sister, you will do this for her. It is the only way you can save her. The pressure must have been immense. Tragically, she was in fact beaten to death. There was no suggestion that her willing participation might have been a possible defense in any which way whatsoever. And fourthly, my ability to count hasn't got any better. In terms of public policy, I think it would be mistaken to widen the category to include exorcism within the exempt activities. There is inevitably an imbalance of power, somebody who believes that they're in need of this kind of intervention. Someone who is doing it is claiming expertise. That itself is worrying. And also the nature of the underlying beliefs, which are also present, make it intrinsically dangerous, because there is a big risk that if a person tries to withdraw their consent, it will be misinterpreted as the voice of the demon or the jinn actually trying to plead for mercy rather than the human being who is being harmed. So for all these reasons, I do not think that it is reasonable or defensible to include exorcism within the list of exempt activities. However, having outlined how grossly unreasonable and frankly barking I think that is, I have to disclose that the Court of Appeal in New Zealand did in fact do it. I do believe that I have cogent reasons to argue that they were misguided, but nevertheless, in the Crown against Lee, the New Zealand Appellate Court looked at a case, again, of a woman who had been beaten to death in the course of an exorcism ritual, and they were extremely critical of the House of Lords in Brown as being unduly paternalistic, and said that effectively consent should at least be considered as a possibility. It would have potentially given the defendant a defense. because he was being charged with manslaughter and it had to be predicated on an illegal act. And the argument was, well, if her consent was operative, then the act was not illegal. I am staggered by any serious suggestion that this person could have consented, although admittedly that wasn't what the appellate court was asserting. She was a new arrival to New Zealand. She did not speak English. She was in a house with fellow nationals who spoke her language. She was actually living with the pastor of the small community church and effectively the faith group, which ended up beating her to death in a ritual. She had no easy ability to ask for any outside help or intervention. There are no witnesses other than the faith group themselves to exactly what took place in the room where she was. They seemed, when the police interviewed them, sincere, but also confused and also quite afraid of their pastor. Joanna Lee, the victim, could not have been a more vulnerable person in terms of the imbalance of power and her inability to ask for help. The reason, incidentally, I've put some flowers there from the place where she grew up and where I hope she was happier than she was in New Zealand is that I have been unable in all of my investigation to ever find a picture of this woman. And I do think it's important not to lose sight of the fact that these cases and the sensational facts they often have concern real human beings who lived real lives and really suffered. And this was a young woman who did not deserve, nobody deserves to have their life end in such a horrible accident. And I believe that the case very firmly illustrates the danger of even opening the door to consent as a possible defense here. In excluding it, we are drawing a very bright line around what the legal system will tolerate. It's also worth making some observations about the context in which what I've deemed violent exorcism, so exorcism involving beating, usually takes place. It's frequently done in a domestic setting. The perpetrators are very often family members rather than religious ministers. Even in a case like Lee, where the person instigating and leading what was happening was a pastor, he was somebody who nevertheless shared a house with the victim. Churches and other faith groups are often, not always, but often on the fringes of what's actually going on. They might know that the family are concerned about the person, but what's going on behind closed doors is often at the instigation of other people. It can be quite difficult to differentiate this from other forms of domestic abuse. And it is striking that even among the adult victims, we are usually dealing with people who, in a sociological sense, are quite disempowered. We are often dealing with individuals who are teenagers or just coming out of that phase of life, so sort of very early 20s. And we are often dealing with female victims. Statistically, the overwhelming majority of the victims that I have read law reports about have been women. And there are questions about how far this can be used in some circumstances as a method of effectively coercion and control. Again, is it something we really want to open the door to further? It's also worth noting in passing that generally speaking, in other contexts, the law takes a dim view of trying to use religious or spiritual motivation as a justification for violent or dangerous practices. In April this year, there was a criminal case actually in the city where I live, in Nottingham, of a healer who practiced in the Zimbabwean community in the UK, who purported to be able to carry out spiritual healing and to connect people in need of care with their ancestors. He was trying to carry out this kind of spiritual ritual, probably not quite within exorcism as we defined it, but on the borders and certainly related. And he encouraged the patient participant to ingest nicotine. Unfortunately, she had an underlying heart condition and she died as a result. Again, the spiritual dimension to it was not considered as any sort of defense. Neither was her enthusiastic participation. I would be inclined to agree that that was a correct outcome. And therefore, if we don't tolerate it in that kind of instance, should we treat exorcism really as anything different? It's probably worth mentioning in passing, though, that in this case, the defendant did describe himself as a herbalist, and it was a commercial arrangement. There was money changing hands. So there are reasons to ask whether it was on all fours, and I would take that criticism. But in summary, when dealing with adults and consent, my bottom line would be the law is in a good place as it is in drawing a bright line, and I would support that line. Moving on to exorcism and minors. This is also quite a distressing topic, to say the least. There have been a number of high-profile tragedies in the United Kingdom and indeed elsewhere in the world, where children have been killed in the course of exorcism rituals and rituals to do with related beliefs. The criminal law, again, at one level is quite clear, and I think is unarguably correct in that the standards in terms of child cruelty and the standards in terms of intervening are objective, they're not malleable for any cultural or spiritual reasons. And if a child is physically being subjected to abusive treatment, then your motivation for doing that is utterly irrelevant, and that has to be correct. More controversial and complicated, though, is the question of how far are non-physically dangerous exorcism practices and assertions around children and young people intrinsically problematic. The charity Africans Child Abuse was set up in the wake of the Victoria Climbié tragedy, and it campaigns not just around this, but around a wide variety of issues to do with children and their welfare, but does argue that accusing a child of witchcraft or possession should be a criminal offence, and they say that this is an intrinsically harmful and damaging thing to say to a child. They say that in this particular cultural context, particularly of the African diaspora community, it will be interpreted by the child as an assertion that they are no longer human and that they are dangerous, and that this has inevitable harmful consequences. There have been attempts also to introduce legislation introducing basically a blanket ban on the exorcism of minors. For instance, the Exorcism of Children Prohibition Bill of 2001. It's also true that this is something which is often thought about, particularly where children are concerned, as being a problem phenomenon that is associated with African diaspora communities. That I would want to squash a little bit. I'm not denying the real seriousness of some of the issues and the very particular cultural considerations in that context as they operate in this country. They are very important and they do need due attention. However, I think it's gravely mistaken to pigeonhole exorcism of minors as being something which is only a concern for one particular subgroup within our society. It's an issue which can be and is controversial for many people in many situations. For instance, the Danish evangelist Torben Sondergaard and his Last Reformation movement are well known as a faith group which attract, not exclusively, but often attract middle-class white professionals, and have certainly been involved in controversial instances offering exorcism as a way of curing autism. I hope that I don't really need to elaborate why offering that kind of intervention is likely to be intrinsically damaging. Not only are there big questions about the appropriateness of using the word cure in the context of somebody who's neurotypical, making an effective promise assertion that we can change how you are and how you experience the world, and how that's likely to be for that child, especially when it doesn't come to pass, is extremely difficult. So the issue of exorcism of minors is a general one. There are legitimate causes for concern, and it is not something which relates only to a single community. Having said all of that, I would not personally be in favour of a blanket ban, not least because it would effectively outlaw Anglican, Roman Catholic and various other baptism rites, which do contain the residual tail, if you like, of medieval exorcism service. And I'd always thought for a long time that this was something that often clergy barely noticed and didn't even consciously necessarily see as an exorcism. But I have been aware that there are certainly come across at least one Roman Catholic priest who does regard the exorcism bit as being a real and important bit of the service. So it's something that is still present within the self-understanding of some people, practicing very mainstream Christianity. And I think it's fair to say that whether or not something is dangerous and damaging when it comes to the spoken word depends massively on the cultural context into which it's been spoken. How will the person receive and hear those words? The same words can send a very different message depending on what is being thought about. So one, the potential for harm varies wildly. Two, if we were to legislate saying that exorcism of children was illegal, well, then secular courts would have to come in and start effectively interpreting theologically liturgical texts and making decisions about whether something was exorcism or not. Presumably, it would be pointless saying that, well, it's only exorcism if the faith group defines it as such, because then no faith group in its right mind would define their practices as exorcism. And two, as we've already discussed, often exorcism, particularly when it's a dangerous kind of phenomenon, happens away from the mainstream action of the faith group, happens in domestic environments. So my view is that we would be better redoubling our efforts to identify and respond to concrete instances of abuse, and to work around educating teachers, healthcare professionals, and other people who might encounter vulnerable children and young people to try and identify red flags rather than banning as a wholesale matter. Another aspect, of course, of the complexity of a complete ban is that it would seriously curtail the religious autonomy of young people. Because, of course, not every minor who's being involved in exorcism is a primary school child who can't make any meaningful decision with understanding to go along with what's happening. Consider, for instance, of a teenager of a Christian denomination, a Christian church, where exorcism and deliverance is a fairly normative part of their spiritual practice, something that happens in church worship services. A 14 or 15-year-old might be doing something which is very normal, unstigmatized and unscary for the community in which they're a part. Suddenly to have the state come in and tell them, oh, you can't do that, that's quite difficult to justify. And I also think it would be quite difficult to justify in terms of Article 9 of the ECHR, which, as I'm sure you're aware, protects the freedom to hold and manifest beliefs. The other thing about teenagers and exorcism is that it's hardly letting out a secret to say that young people are very often drawn to the paranormal, to the occult. They are fascinated by this. And there is an awful lot of material out there on the internet. Trust me, I've looked, and it's amazing and worrying what's actually out there. Now, I'm not necessarily saying that an unhealthy interest and desire to dabble in this in the part of teenagers is a good thing. I'm just pointing out that it's one of many things that teenagers are keen to experiment with, whatever older people might think. And given that it's out there, there are people, all sorts of people pushing this and helping this. it's really hard to see how the ban could be in any sense meaningfully or effectively enforced. So for all of those reasons, I would be reasonably content with the current state of the law, but suggest that there's perhaps more we could do in terms of social policy when it comes to helping to ensure children are protected and no other little child suffers the way Victoria Klimbe and various other children have. Moving to my third topic of issues of civil liability. And I'm going to be thinking primarily in terms of liability in negligence. There are obviously other forms of civil liability that we might consider, but we don't have all night. And there are two principal ways that I can see exorcism potentially resulting in civil liability as far as the tort of negligence goes. Firstly, someone offering an exorcism and then the person who's received it saying that they've suffered psychological harm. Secondly, somebody who's been the recipient of an exorcism ritual who then goes on to harm themselves or others. And as I'm sure you're aware, there was a very tragic incident with facts along those lines that instigated the modern guidance and era of deliverance ministry. Could either of those kind of situations generate civil liability? Well, firstly, exorcism and psychological harm. There has been a recent-ish case on this in 2018, the Brayshaw case, which involved a locum GP. And effectively, a doctor who was a locum used his position as a doctor as an opportunity for evangelism and persuaded a female patient who had a variety of mental and emotional challenges to go along to his church and to spend time with him and his wife. For a while, this was quite a happy arrangement by all accounts as far as the patient was concerned, but relationships broke down and she basically was very unhappy. She said in particular that she had suffered harm as a result of a service that she had attended that involved exorcism and also involved a distressing story about an owl. This resulted in her suffering a recurrence of depression, which she had previously experienced, and also developing a phobia of owls, which I think is rather a shame as I'm quite a big fan of owls. But also the reason I mentioned that, not just to have a picture of a lovely owl, is that along the depression was something tangible and concrete which could be identified and acknowledged and diagnosed by a doctor. And this was relevant to establishing claim in tort. The doctor concerned was found to be negligent. I think that's unsurprising given his behaviour had been grossly unprofessional and completely flying in the face of all good ethical practice. The reason the case was reported instantly, interestingly enough, really concerned vicarious liability and whether the practice should be liable for a locum. It was found that they shouldn't, and that's an interesting strand in itself. Those of you who know me know that vicarious liability is also an interest of mine, but I won't indulge myself by talking about that any further. I think it's fair to acknowledge that the Brayshaw case is fairly unusual and isn't something which I think people involved in Anglican parlance and deliverance ministry and in other traditions, things that come within what we've described as exorcism, should be unduly worried about. As I've said, it concerned a doctor, somebody who had professional expertise and clear boundaries of behaviour that he transgressed. It was unusual in that there was not only a diagnosable psychiatric condition, it was possible to tie that in a concrete way to what had happened. Because quite often the people in receipt of exorcism do have certain challenges and vulnerabilities across the board. And it can be very difficult to show that any deterioration in mental health was necessarily a result of a particular practice that they didn't indulge in. However, on these facts, it was possible to establish causation. A religious minister, or indeed a member of a faith group carrying out an exorcism, is going to be in a very different position. There is no claim of clinical expertise. There are not boundaries which have been transgressed. And in factual terms, it will be unusual to be able to prove causation so effectively. Ordinarily, in order to establish liability and negligence, you need to be able to show that there is negligent behaviour, so that somehow the minister, or if it's a kind of commercial arrangement, and such things are indeed available, if you again Google it, that they somehow failed to provide a reasonable, competent service. It's going to be very difficult to say what is reasonable and competent in these circumstances. It's not like a clinician where there are clear standards. It would have to be reasonably foreseeable that any act or omission, any breach of the standards of reasonable behaviour caused harm. You'd actually have to show causation, and you'd have to show that the harm suffered amounted to diagnosable mental health conditions, something that a doctor could point to and identify. The fact that you've simply caused somebody emotional pain and distress is not something in and of itself that civil law will pay much attention to. That is not suggesting that that should be our threshold within faith groups for good and responsible practice. I am obviously simply talking about what will trigger liability in tort. Turning to a situation in which the recipient of an exorcism has caused harm to themselves or others, the same identical factors would obviously apply in establishing negligence. There is no general duty to warn. There is no general duty to take a proactive interest in other people's welfare in England and Wales. So this means that, generally speaking, it's not going to be easy to say that anyone involved in an exorcism should have protected third parties from the potential behaviour of somebody else. However, having said that there is no general duty of care or duty to warn, it is possible to imagine circumstances when a duty has been undertaken. So if you have voluntarily made yourself responsible for somebody's welfare and intervened in a situation, then you may have done enough to have taken on a duty of care. Fortunately, cases like this, making it as far as litigation, are very rare. Within this jurisdiction, I am not aware of reported cases of civil liability, but I certainly wouldn't say never. I could imagine, for instance, if somebody, perhaps, say for the sake of convenience, a parish priest was visiting someone who expressed a desire for deliverance ministry and was disclosing that they had voices telling them that they should kill the elderly, vulnerable parent with whom they lived, and that came to pass. If the priest had been pastorally involved with both of them and was regularly taking part in that whole situation and did nothing to intervene, possibly that's the kind of situation in which you would have been sufficiently involved to generate a duty of care. In terms of torts other than negligence, I think it's fair to point out that hitherto I've been talking about situations in which the recipient of the exorcism has been a willing participant. I hope it's fairly obvious to say that, generally speaking, if you're trying to carry out an exorcism on a non-consenting person, you're almost certainly going to be liable in trespass or false imprisonment, unless, by the way, you live in Texas. There is a reported case from 2008 of an unfortunate young woman who was forcibly subjected to an exorcism by a Pentecostal church, and the Texan appellate court was of the opinion that in joining a church which practiced exorcism, she'd signed up to that kind of thing, and it would be too dangerous and too problematic to make them liable in negligence for being overzealous. I honestly cannot in a million years imagine a court in England and Wales coming to a similar conclusion. It's an interesting illustration of how important cultural expectations are in how courts deal with things, even when it comes to civil liability. It's also, on the subject of civil liability, impossible not to mention vicarious liability in this context, especially if you're me. But it's worth noting in passing that religious groups should be aware that they cannot escape responsibility for their representatives simply by encouraging, indeed requiring good practice and having robust policies in place. Vicarious liability is the legal mechanism which makes an employer or somebody who is receiving the benefit of another person's services when they're in a situation which is regarded as being in some ways akin to employment, liable for what they do. It's a form of strict liability. So if your representative does something negligent, you will be treated as though you had done it yourself, even if you had done everything in your power to prevent that happening. Depending on your legal interests, you may or may not be aware that the Supreme Court recently has been sort of slamming the brakes on a bit with vicarious liability. It had started to become a bit of a Frankenstein's monster, and it was getting to the point where people were being liable for an awful lot of things that they couldn't really control. The reason I'm mentioning that is that that tendency to pull back doesn't seem to be happening in the context of faith and faith groups. So we have a very recent case from a few months ago of the trustees of Barry Congregation of Jehovah's Witnesses and BXB. And in this case, the court was prepared to find a church liable for, in this case, sexual assaults committed by a layperson who had some responsibilities. So no question that vicarious liability is still a legal mechanism that has real teeth, especially where faith groups are concerned. And although it's quite difficult to generate civil liability in the context of exorcism, it's certainly also very possible. And if one of your representatives does that, then you're going to be on the hook for it. Having said it, I wanted to finish with a slightly lighter note, because despite this being a talk about exorcism, I did not want to unduly frighten any of the participants. As I've emphasised, I hope, when it comes to civil liability, it's going to be contingent. It's absolutely a sine qua non that you have to have someone who has suffered either physical harm, diagnosable mental illness, or property damage. And that has to have been caused by the defendant or the defendant's representatives. So it's not an easy threshold to make. If you are behaving responsibly within the guidance that most faith groups set down within their own internal canons or other structures, you're going to be going at some if you succeed in doing that. The reason, though, the salutary lesson, the picture is of a street, an unremarkable suburban street, again in Nottingham. I'm not sure what this says about Nottingham, a place called Long Eaton. And the fire brigade arrived and costs were incurred as a result when effectively a group of people carrying out an exorcism by burning sage had been a bit overzealous and set fire to the house. So obviously, if you succeed in doing something genuinely daft and dangerous, well, you can expect that you're going to have problems. If you avoid that and you act within reasonable bounds of what is expected, the standards which the law of the state sets are really quite wide and generous. And I would hope better practice from anyone involved in any kind of responsible faith organisation. So I wouldn't want to give the impression that civil liability is a spectre stalking you all. Thank you very, very much for your attention. Again, for your really kind invitation. I have hugely appreciated it. And I would be very happy to take any questions which Anne-Marie might want to forward my way. I'll stop sharing the screen as well.
Helen, thank you very much indeed. absolutely fascinating. Thank you so much. I will leave a few comments I've got and my own question into for a moment, because I think if we could start, you can probably see some questions in the chat there. So if we could start, Anne-Marie, with Neil Patterson. So Neil, if you could put up your blue hand or your electronic hand, then Anne-Marie will be able to find you and you can ask your question.
Sorry, you can now hear me, and I'm just trying to find. Do I still also need my hand?
That's fine. Let's go for it.
So my question was really about you talked, it seemed quite cheerfully, about churches where there's an accepted culture that young people might receive exorcism as part of it. But given that can also potentially be an abuse of power, how one can imagine that? I don't want to sort of describe. I mean, a lot of the stuff about conversion therapy related to it. How then do we find a way to discern, I suppose?
Yeah, I think that's a really good question. I mean, obviously, it will depend upon the authorities and the policies of the denomination with which it's been taking place. And you would hope that any respectable church would have robust safeguarding policies and would have robust thoughts about what they did and didn't allow during worship. I can well imagine practices going on in some contexts that were unhealthy for young teenagers and arguably adults. I think my point is I wouldn't necessarily want to deal with that by a blanket ban in terms of secular law. I don't think that's the level to go in. I do think that you need to have robust policies yourself, and that's going to depend on the theology of the group. But you need to be clear about what you're doing, what the risks are, have good safeguarding policies, and make sure that they're stuck to. And also, I think it's a fair point that that's the sort of context where if you do cross over a line, you could imagine a successful seed. You could imagine if you engage in something like conversion therapy, there's overwhelming psychiatric evidence that that is potentially damaging. And I could well imagine somebody, yes, establishing a causal link and having a successful claim in tort. So, yeah. Does that answer the question to a degree?
Anne-Marie, if you could just unmute me.
I muted myself again. Yes, thank you very much. No, very helpful. I think this is something for us all to be aware of as these debates go on, really. Thanks.
Thank you.
Thank you. So if we, if I could ask both Mark Bratton and Emily Kempson to pop up their electronic hands. We'll go to Mark first, but then Anne-Marie will be able to find you. So Mark and then Emily. And do keep the questions coming. Just pop them into the chat, or that will be great.
Thank you very much for that talk. This is a really fascinating area. I mean, you were dealing with really hard cases, and your analysis was a criminal law analysis and a medical negligence analysis. But I was just thinking of a slightly different kind of medical law analysis on the consent best interests axis. And just imagining a case where you have an episcopally sanctioned, multidisciplinary consulted major exorcism. It just really interested me to speculate about whether the candidate for major exorcism would be incapacitous by definition, because I'm just thinking of those 19th century probate cases which talked about the overbearing of the will. I mean, would not the candidate's will be overborne by definition, or at least her lucidity fluctuating? And even if one conceded that, would one nevertheless be able to justify the major exorcism by appealing to the medical best interests tests, which takes into account not just medical factors, but non-medical factors as well? It's a bit of a it's hypothetical so far. I'm not aware of an episcopally sanctioned exorcism having been litigated, but I just wondered what your thoughts were.
Yeah, I mean, I think it's a fascinating question. A lot would depend on how it came to court. I mean, firstly, of course, consent is decision specific. So somebody could, in theory, be quite incapacitated for some purposes and still make a decision. Whether a psychiatric team would ever be willing to go down the route of a kind of therapeutic exorcism if that wasn't something that made sense from the spiritual point of view of the person and the tradition that they normally moved in, I find it very difficult to imagine a situation where they would do that, where it was something that wasn't, you know, cogent with where the person was coming from. Mm-hmm. So that makes it highly unlikely you get a claim in trespass to the person. So basically, you touched me without my consent.
Yeah. And
also in a medical context, in this jurisdiction, we tend not to go along with trespass very much. You know, if a doctor doesn't properly explain surgery, then trespass won't be used, we'll use negligence. So that means once you've thrown trespass out of the window as well, the claim's not going to arise that way. It's going to be very difficult to see how you could make out a claim in negligence, because you're dealing with somebody who was presumably in quite a poor state to begin with. So showing that you have caused psychiatric harm in doing it, that's going to be nigh on impossible. And I suppose, if in some way the person became distressed, moved in a sort of jerky way and managed to physically hurt themselves, or maybe, but then I would think that would be a matter of liability for the clinicians who weren't managing a therapeutic situation in a hospital well. Those would be my initial thoughts from the top of my head anyway. I don't know if that goes some way to addressing what you were thinking.
I mean, I find it fascinating. Kind of looking at it, it looks one way when you look at it through the remedial prism. Is this trespass to the person? Does the bishop or the attending clinicians fall foul in negligence? I guess what interests me is, whether if you were genuinely possessed, and of course one's putting a spiritual spin on this, one could satisfy the requirements of a legally valid consent because one was simply incapable of making a voluntary decision because of the spiritual.
Yes, I mean, I think
counterposing will to which you were.
I think if you had spiritually correctly diagnosed somebody as being in need of a major exorcism because they were in fact possessed, then spiritually and theologically, it's quite clear that they wouldn't be able to give consent. But obviously that's not something that secular law would be able to take cognizance of. Because, as William Blackstone said, it's not that I don't necessarily believe in things like that. It's simply that we don't have the kind of evidence that we can deal with as lawyers.
Yeah.
Thank you very much.
Thank you. Thank you very much indeed, Mark. So let's go to Emily Kempson, and then Anne-Marie, I know has got a question. Emily.
Hello. Thank you, Helen, for your presentation. At one point, you alluded to a particular case from a few decades ago that led to the changes and led to the current Anglican approach to deliverance ministry. I wondered if you could just detail that because I'm not familiar with it, or what specific changes resulted from that case. Thank you.
Okay. Yeah, I mean, there is certainly, it's well described in the literature around exorcism cases. It happened in the north of England, and the facts are absolutely horrible, but basically a man received what we would refer to as deliverance ministry from an Anglican, and I think a Methodist minister was also involved. Within a very short space of time afterwards, he brutally murdered both his wife and the family dog in the most appalling way imaginable. And This led to the Church of England and also some other faith groups of which I'm aware deciding that they really needed to have modern, appropriate guidance as to how these kind of situations should be handled. You know, whether or not there was a direct causal link, certainly the pastoral response to that situation, with hindsight, was disastrous, to put it mildly. But yeah, I can sort of link to some books that describe it, if that will be helpful. Mm-hmm.
Thank you. Thank you, Emily, for that question. Thank you, Helen. Anne-Marie.
Yes, the government has announced its intention to ban conversion therapy, and exorcism is often part of conversion therapy. So is there a risk that by banning conversion therapy, that it might lead to a ban on exorcism, or banning exorcism by the back door, as it were?
Yeah, I mean, I think obviously one of the reasons why banning conversion therapy has been difficult has been arriving at a definition of conversion therapy. I think it is quite clear that the mischief, if you like, of the ban is intended to be interventions which will cure or change somebody's sexuality. So if an exorcism was directed at doing that, then that would potentially be caught by the ban. I mean, obviously we don't have the draft legislation yet, so it's hard to tell how well it would be. But certainly, although some exorcisms probably could be caught, I don't imagine for a moment that that would be a sort of general blanket ban, because there are plenty of the kind of beliefs that we've been talking about that clearly have nothing to do with that. But yeah, some exorcisms could potentially be made illegal. Interesting question.
Thank you, Anne-Marie, for that. Thank you, Helen. Just Helen, just a question from me. I know you said at the beginning that you weren't going to talk to the specifics of Church of England canon law on the subject, and I'm not going to ask you to open up all of that now. I am conscious as a member of the clergy, of course, that we do receive a degree of guidance on this in terms of going to the relevant diocesan exorcist or deliverance ministers, I should say, in situations. But I wonder whether you could say a little bit, firstly, on your thoughts on appropriate training in that area, both for those involved in deliverance ministry and also clergy in general. And secondly, what tends to happen is that you may be approached, and particularly people may have moved into, this seems to be where it happens often, people seem to have moved somewhere and they think there's something funny about the house, so you go around for a house blessing, and it's never been entirely clear to lots of us, I think, where you start to draw lines and get further help. I don't know whether they're helpful questions, but whether you can...
Yeah,
thoughts on that.
They're very helpful questions, and they're very fair questions as well. I mean, obviously it's something that dioceses organise, so you get quite a lot of differing approaches within the diocese. There obviously are organisations that within the church, deliverance study group. We also have a bishop who has a particular brief for deliverance ministry at the moment to try to ensure that there is good practice and policy across the board. But in terms of who receives what training and how well things are enforced, that is going to be very much determined by, the regime at diocesan level, and that's hugely varied. I think it is important that parish clergy, and indeed all clergy, know when and how to seek help, and when in doubt to call somebody, and that your diocese has enough people who are able to pick up the phone to you when something happens. I think in some ways the house blessing type situations tend not to be the most hopefully I'm just awfully tempting fate now, but usually they tend not to, in my experience, be the ones that have the most immediate tendency to go south. What from my own experience and also anecdotally from others, can be very difficult are people who persistently come to you demanding effectively a major exorcism, not that they would necessarily use that language, and can be very, very persistent in their demands. And also deliverance ministers can be very useful in the best cases in helping to point you in the direction of support for people who need mental health support and guidance. I think the other thing I'd say is a matter of frustration is that mental health care is not good in England and Wales at the moment. And you can often be in a very frustrating situation in terms of even people asking help and willing to access services. If you have a situation where somebody really needs some clinical intervention, but probably isn't sectionable and is resistant to that, then actually having an experienced colleague who can help perhaps have kind of supportive conversations with that person, encourage them to their GP, that really can be invaluable. And that's something that's really important, that deliverance ministers are able to provide as support, I think. Those are quite disparate thoughts. I don't know how helpful they were.
That's really helpful, Helen. Thank you ever so much. Two questions here. So I think Mark Headley has his hand up. Mark, could we come to you? And then there's a question in the chat after that from Lorraine Apps-Huggins. So Mark Headley first.
Thank you. Helen, thank you very much for that. My experience of exorcism is as a judge in the Court of Protection and in the Family Court. And my experience has been slightly sort of widened by the fact that exorcism does crop up from time to time, but usually where there is an aura of ongoing abuse of one sort or another, so that it's quite difficult to separate out the exorcist element from an overall abusive element. I don't know whether that coincides with your experience or not. And it's also sometimes extremely difficult to separate it out from prevailing cultural assumptions, particularly in minority communities that one is likely to come across. I just don't know whether you've got any sort of general comment on that might be helpful.
Yes, thank you very much. That's a really helpful observation, and it's really valuable to have your experience and your perspective. It doesn't shock me from my own research, I have to say. As I alluded to in the context, of consent, often a lot of this is taking place within what looks to be an abusive domestic situation. Especially as the kind of exorcism practices which are often dangerous and painful are not being done by faith groups in an organized way. A lot of the time they're being done by families or members of the community coming into a domestic home. And it's often about controlling children and controlling women, or controlling adults who are young adults who are challenging authority, which can be quite problematic for the cultural context in which they move, which is my suggestion sometimes when you see it with people in the late teens, early 20s, especially daughters, but not exclusively so. And there's a tendency to, of course, to interpret behavior through the cultural lens that you see the world through. That's inevitable. But that can be a way of explaining what are regarded as deviant behaviors. And sometimes they might, of course, be the result of mental health episode that the person's going through. That might be why the behavior is odd, or it might just be, in some cases, that it's not even a mental health issue. It's just pushing up against authorities and boundaries. But I absolutely agree, and I think we have to be very careful that we don't label what is really domestic abuse as a spiritual practice.
Thank you.
Thank you.
Thank you.
Well, thank you for that question. Thanks, Helen. So we've got maybe more of a comment than a question, but from Lorraine Huggins. Lorraine, I wonder whether you want to ask that, and then we'll go to Mark Smith.
Oh, sorry, I think you're still on mute.
I think, Lorraine, your sound's not working, I think, even though you're not on mute. The comment was, we are still in the Lord's Prayer, deliver us from evil. I believe much deliverance happens gently and without our awareness. Good Christian care and community have so much to offer. I wonder whether you might want to comment on that, Helen, and then we'll go to Mark.
Yes, I mean, absolutely. And as I did say towards the beginning, I'm conscious that inevitably when I'm talking about, criminal and civil law, I am talking inevitably about the cases that have been harmful. And that does not mean that I'm suggesting that exorcism as practiced by most Christians or as, by other cultural groups is necessarily harmful. Many practices are not at all harmful. I'm not suggesting that this is this whole area is a bad thing necessarily. It's just that inevitably, as someone who specialises in tort and crime, I tend to talk about bad things because it's what we do.
Thank you. Thank you very much. Mark Smith.
Yeah, I fear my question might seem to be being a bit flippant, but it isn't really. It's just looking at the other side of the coin. Is there a risk of a lawsuit when someone thinks that they're going to receive some form of deliverance, goes through a process and it doesn't work? They've relied upon you as the person saying this might work and it doesn't happen. I'm not trying to be a devil's advocate here, but you can get the point.
Yeah, absolutely. And I think I think the short answer is potentially yes. I mean, I suppose the sad and serious situation could be if you're dealing with something that should never be going on in the first place, like someone who's claimed to cure someone's sexuality or their neurostate. But the sort of slightly less, well, it's not very funny if you're involved in the situation. But as I've alluded to, it was something I chose not to talk about very much because of limited time. But if you Google, you will find people who will, for a fee, provide you with spiritual cleansing services and effectively commercial exorcism, as I find it. And if you are making a commercial agreement with somebody and it doesn't come to pass, and it would be difficult because obviously, as I've said, the secular law is not going to get into the rights and wrongs, and it might be, well, all you promised to do for the money was to go to the house and do whatever you did, and they went to the house and did whatever they did. But if they had actually just made an open-ended assertion that we will remove this mysterious smell from your home, and the home still smells because it's actually drains, then maybe they could have a claim in contract. I haven't yet found one, but given that the increasing popularity, it's probably only a matter of time. So yeah, thank you for that.
Thank you, Mark. Any final questions? Okay, there's nothing else in the chat, I don't think. So just before I thank Helen, just before that, and we bring this evening's lecture to a close, a reminder to everyone that details of the Society's future events can be found on the Ecclesiastical Law Society website. In particular, can I draw your attention to the next online event, which is the Northern Province Lecture on Wednesday, the 16th of June at 5:30 p.m. on Zoom, which will be delivered by the Bishop of Newcastle, the Right Reverend Christine Hardman, on the importance of ecclesiastical law in facilitating the mission of the Church. And then on Thursday, the 8th of July at 5:30, there's a webinar, Religion and Marriage Law, the Need for Reform, to mark the launch of Russell Sandberg's new book in this area. Many of you will know Russell, Professor of Law at Cardiff University. So that should be very good indeed. And then the next London lecture Wednesday, the 15th of September at 5:30 p.m. will be delivered by the Dean of the Archers and Auditor, Morag Ellis QC, entitled Clean and Green, Law and the Carbon Neutral Church. I very much hope that that lecture will be held back at Winkworth Sherwood in London, to whom we're very grateful, restrictions permitting. But if not, we will be here on Zoom. But all are as ever welcome, and bookings for lectures and events can be made on the ELS website. There's a lot of thank yous going on in the chat, which we can see there, but I'd like to thank you all for joining and for the very thoughtful questions, and a particular thank you to Anne-Marie for flawlessly running the technology, which is a great reassurance to all of us. Thank you, Anne-Marie. But most of all, on behalf of you all, Helen, absolutely fascinating lecture. I've learned a huge amount. Thank you so much. And as you can see, lots and lots of thank yous there in the chat. Thanks ever so much. And we'll see you all next time, I hope.
Well, thank you so much.
Thank you. Bye-bye.